Family courts operate under a clear, universally recognized mandate: prioritize the safety, stability, and best interests of the child. Yet the institution is cracking under the weight of its own processes. For the families navigating this system, the lived reality contradicts that mandate. They experience a process that generates prolonged conflict, escalates hostility, and drains their savings. This disconnect is often blamed on the raw emotions of divorcing parents, but the evidence points to a different source. The catastrophic outcomes are a feature of the system's structural design. When a service provider's profit increases as the customer's situation worsens, the economic model is in direct conflict with the intended outcome. In economic terms, the family court functions as a market failure. When a system's internal incentives deviate from its public mission, it inevitably prioritizes professional norms and revenue models over the people it was built to serve. To understand why this happens, we have to look at the family court as a systemic black box. The inputs are straightforward: family disputes, human emotion, and the developmental needs of children. This diagram shows what happens during processing. The disputes enter on the left, but what exits on the right are escalating hostility, exhausted savings, and traumatized children. Inside that black box sits an adversarial engine driven by institutional mechanics. We are going to reverse engineer these specific gears and feedback loops to see exactly why the engine malfunctions. The harm to families will continue until we dismantle the specific economic and procedural machine generating it. Every decision made inside this engine is supposedly governed by one standard: the best interests of the child. In practice, that phrase operates as a rhetorical blank check. Attorneys use it to justify entirely opposing outcomes, depending on which parent they represent. Objective data about a family's lived experience enters a systemic filter. Attorneys warp these raw facts into specialized legal storytelling. The goal is to fit precedent, not reality. What emerges are competing narratives designed strictly for strategic dominance. By warping the data to fit a strategy, the process creates an information gap. The court is effectively blinded to actual patterns of abuse or subtle coercion. This dynamic shields professional discretion. Judges are left to rely on the most persuasive story rather than verifiable data. This information gap guarantees that the court is adjudicating legal strategy, severing the process from the child's actual reality. The engine requires fuel, and the legal profession is driven by one primary economic unit: the billable hour. A family enters the system seeking resolution. For the professionals managing the case, rapid resolution represents a direct loss of revenue. This economic reality collides with the attorney's ethical mandate of zealous advocacy. In family law, winning for one parent requires aggressive posturing. This tears down cooperative co-parenting structures and damages the child's long-term stability. Aggression triggers retaliatory filings. Filings force formal responses. Responses multiply billable hours. This circular feedback loop, filings, hearings, billable hours, creates a time tax levied directly on trapped families. This prolonged litigation expands downward, swallowing a child's finite developmental windows, enforcing chronic instability. The system effectively punishes de-escalation because cooperative solutions are structurally unprofitable. The standard defense of this system is that state bar associations and accountability protocols exist to regulate attorney behavior. Those oversight bodies focus on technical rule compliance. They do not measure or penalize outcomes for the children involved. Systemic cross-tase patterns of escalation or harm caused by specific practitioners go untracked. The system relies on procedural layers that are difficult for outsiders to navigate. This complexity acts as an institutional moat, shielding the profession from scrutiny. In this procedural labyrinth, self-represented individuals hit dead-end traps, where minor formatting missteps override case facts. Meanwhile, legal insiders bypass barriers using structural shortcuts, navigating the maze with ease to their strategic advantage. This uneven playing field ensures that hiring an attorney remains an absolute necessity. A family's access to justice is therefore dictated by their capital. The outcome depends on the quality of representation they can afford. Accountability networks and procedural rules exist to protect the profession. They ensure the machine keeps running, while families remain trapped inside. To fix this, family courts must abandon the professional-first case management model and transition to a genuine child protection framework. The first required structural shift is the elimination of subjective storytelling. It must be replaced with standardized, objective data. This chart contrasts the two models. On the left, chaos. On the right, clean data, communication logs, behavioral pattern tracking, and explicit well-being indicators. The second structural shift requires changing the court's primary operational metric to prioritize de-escalation. When success is measured by the reduction of harm, it breaks the economic incentive for prolonged litigation. Access to the system must also be democratized. Implementing plain language workflows and AI-assisted documentation removes the dependency on expensive legal navigation. Finally, oversight must be moved outside the legal bubble. Independent review bodies need to track long-term child outcomes, rather than checking if attorneys followed technical formatting rules. True protection for families requires intentionally dismantling the legal profession's monopoly on procedural complexity. The suffering seen in family court is a solvable engineering problem. Because the harm is generated by structural choices, it can be undone by structural reform. A system cannot optimize for adversarial legal strategy and ensure child safety at the same time. The mechanics of one inherently destroy the other. Systemic transparency and data-driven protocols are the only proven antidotes to this specific market failure. The court system must evaluate its success by the health and stability of the families it heals, rather than the volume of cases it processes. Protecting the profession and protecting families have become mutually exclusive goals. It is time for the system to choose the families.